Hello everyone. So we are going to start our next part, that is in the Companies Act, about chapter 10, where we are going to talk about our auditors. Okay. So till now we have completed chapter 9, where I have not only covered few chapters of your syllabus, I have also tried to cover those parts which I have never been mentioned in the syllabus, but questions have arrived from those particular parts. Okay, so let's begin with our today's session. So this is your chapter 10 auditors, where we are going to talk about different sections, in which we are going to talk about the appointment of your auditors, then their exit, eligibility, pay, work. Along with that, we are going to talk about the powers, duties, auditing standards, what services they cannot render, and how they can sign those reports that they have audited. And also we are going to talk about the general meeting part, punishment for contravention of this particular act. So that is section 147, will be talking about it, and in the section 148 we are going to talk about your cost auditor. So let's begin with our today's class. So first of all, we are going to talk about our section 139, where we are talking about the appointment of auditors. So now think of section 139 as the who is appointing the auditor. Okay, who is appointing an auditor. Then we are going to talk about when is the person going to appoint that particular auditor, and for how long this appointment will go on, right? So now you have to understand some basic facts. So here, that we are dividing the particular part into four situations, where we are going to talk about the normal appointment. Okay, the normal appointment that is taking place at what? It is taking place at the annual general meeting. Then we are going to talk about your first auditor of a normal company. Okay, and then we are going to talk about first auditor of a government company, right? And then we are going to talk about what situation, that is casual vacancy. So here never mix with the first auditor and auditor appointed at the AGM. So first of all, let us understand the big picture. So imagine there is a company ABC Limited that has been incorporated in, let us say, 2016. Okay, in the year 2016 this particular company was incorporated, or let us say 1st April 2016. Now we are saying that okay, someone has to audit its account, but we have to also ask whether the organization is a private company or a government company. Also, let us take another organization as XYZ Limited that has been established in 1st April 2026. Okay, so we are taking two organizations. Now we are going to talk about whether these companies are private companies, government companies, right? Now, if there are a normal company, we are saying that okay, who will be appointing the first auditor? So in this particular case, let us say this is a normal company. We are going to say that okay, here the board of directors will be, or the board members will be appointing the particular auditor. And if it was a government company, we will say that CAG and then board and then members. So here you have to understand few things. So that once the company reaches its first AGM, the company appoints an auditor. Fine. So the appointment is made by the members of the company at the AGM. The auditor can be an individual or a firm. So the auditor originally holds office from the conclusion of that first AGM until what? The first meeting or the 6th AGM, until the conclusion of the 6th AGM. So this is basically, we are saying that there is a 5-year tenure structure. Okay, understood? So here we are saying that this is basically asked in the exam also. So in the first AGM, you will see that all the members of the first AGM will be appointing the auditor, and AGM appointment will be basically for a long-term auditor. Now we were talking about another company, this is XYZ Limited, where we were saying that it was incorporated in 2026 and its first AGM is, let us say, that will be held on 30th of September 2026, right after completing 6 months. So here we are saying that okay, at its AGM it has appointed, let us say, some GHI, okay, company limited, and with chartered accountants. So here you will see that the members are going to appoint whom? This GHI and Company Limited, which is becoming the statutory auditors from the conclusion of the AGM. Okay, so here first of all you see it governs the rules, timelines and procedures for appointing the first and subsequent auditor for both government and non-government companies. So every company shall appoint an individual or firm as an auditor at its first AGM. In our case, we had taken the example for this for XYZ Limited, where they had appointed whom? GHI and company. Okay. Now we are saying that okay, company shall inform the auditor concerned of his or its appointment and file a notice of such appointment with the registrar within 15 days of the meeting in which the auditor is appointed. So now we are seeing that after appointment is done, the company has another responsibility where it must inform the auditor and file notice with registrar of companies, and the notice will be filed through which form? Form ADT1. Okay, form ADT1. Now here what we are saying that normal filing period is 15 days from the meeting in which the auditor is appointed, and you have to understand it. Auditors will be appointed, then you have to file this ADT1 with ROC, and then within 15 days you have to file this, right? Now consider we have a specific IFSC, public or private company. The 15-day period is modified to 30 days. Okay, because of IFSC. So for IFSC, this is somewhat different. It is for 30 days. Okay. Now next to, in case of IFSC, public or private company, you will get 30 days for this notice. And now they are talking about notice to registrar shall be in the form ADT1, as I told you. And the first auditor of a company other than a government company shall be appointed by the BOD within 30 days from the registration of the company. So basically we are talking about few important things here. We are saying that okay, the auditor appointed at the first AGM is not necessarily the first auditor. Why? Because before the first AGM happens, somebody might audit the company with the first financial statement. Therefore, here comes the role of section 139(6), where it creates a special mechanism for the first auditor, and we are saying that for a company other than a government company, that is a non-government company, BOD appoints the first auditor within 30 days from the date of registration of the company. Okay, so here let us say that XYZ was incorporated on 1st April 2026. Now it will be counting the first auditor rules. So here you will see that from on 1st April the company got registered. The board of directors will get 30 days of time to appoint the first auditor. Now suppose the board has appointed GHI and Co Limited. So here you will see that on, let us say, on some 15th of April 2026, then it will become its first auditor. Now what if board doesn't appoint these first auditor within 30 days, then what will happen? So here you have to understand that this is a very important change that we are going to understand. So if the board fails to appoint the first auditor within 30 days, board will inform the members. Okay, so board is going to inform the members of the company, who shall within next to 90 days at an extraordinary general meeting appoint such auditor, and such auditor shall hold office till the conclusion of first AGM. So here we are putting few conditions, where in the first step we are going to inform the members, then members will appoint the auditor within next to 90 days, and appointment is made at EGM, that is extraordinary general meeting, and the auditor will continue until the conclusion of the first AGM. Fine. So here this is your proper cycle that you have to understand. So I hope now this is clear that board has 30 days to choose the first auditor. If it says that okay, I forgot to do the same, then we will say that okay, fine, give us 90 days and we will choose one in EGM, and he will be an auditor till the first meeting of AGM. Okay, for conclusion of first meeting of AGM. Okay, now imagine that this particular XYZ Limited, okay, is a government company. So here the first auditor is not initially chosen by the board. Who is choosing them? Comptroller and Auditor General of India within 60 days from the date of registration of the company. So here you will see that under section 139(7), CAG gets how many days? 60 days, while the board was getting how many days? 30 days. Board was hiring people or the auditor for which company? Non-government company. CAG is hiring these people for which company? Government company. Okay, so here you will see that if CAG doesn't appoint anyone, then what will happen? Board will get another 30 days, and if board also fails, then members get 60 days at an EGM. So we got 60 days for CAG. If it did not follow the instruction, then we will give 30 days to our board, and even if they do not fulfill the instructions, then we are giving another 60 days to the members to appoint someone at an extraordinary general meeting. Okay, so in case the CAG, Comptroller and Auditor General of India, doesn't appoint such auditor within the set period, the BOD of the company shall appoint such auditor within next 30 days. And in the case of failure of the board to appoint such auditor within the next 30 days, it shall inform the members of the company, who shall appoint such auditor within 60 days at an extraordinary general meeting. So let's talk about now the casual vacancy part. I hope this is clear to you. So here we are saying that, see, this is a completely different situation. So we are not talking about the first auditor with this casual vacancy. We are saying that, okay, ABC Limited, you remember that was started in on 1st April 2016. Now we are saying that, okay, it has an auditor. The auditor's terms are not actually ended, but suddenly the position becomes vacant. For an example, this particular auditor has resigned, so there is a casual vacancy. So here we have seen that, okay, it has become empty. So basically, when it happens with the normal company whose accounts are not subject to audit by a CAG appointed auditor, board of directors will fill the casual vacancy within 30 days. Okay, but here you have to understand that there is an extra condition for resignation. So in case of a company other than a company whose accounts are subject to audit by an auditor appointed by CAG, basically in case of a normal company, here it has to be filed by BOD, it has to be filled by the BOD within 30 days. What? The casual vacancy. Okay, an organization XYZ Limited, and it has already an auditor. Now the auditor's terms has not normally ended, but he has suddenly resigned and the position has become vacant. So here we are simply saying that, okay, auditor has resigned, so there is a casual vacancy. So basically the chair was occupied, but now suddenly this chair is empty. Fine, so this is a casual vacancy. Here we are saying that, okay, for a normal company, if there is a casual vacancy, fine, then the board will fill the casual vacancy within 30 days. Okay, within how many days? 30 days of this casual vacancy. Fine, here you will see that this resignation is also creating an extra condition, where we are saying that, suppose this auditor has resigned but the board has appointed a replacement within 30 days, as I told you. But here the matter will not get finished, because when the casual vacancy is caused by resignation, the appointment must also be approved by the company at a general meeting. Fine, so here we have to understand the meeting must be convened within 3 months. Okay, the meeting must be convened within how many months? 3 months of the recommendation of the board, and then he will be holding this office till the conclusion of the next AGM. Fine, understood. So here consider that XYZ Limited has one auditor or auditor firm. Let us say Mr. A is there. Okay, let us take just an auditor rather than an auditor firm as our example. So on, let us say 1st June, he had resigned. Now vacancy occurred. Now board will be filling this vacancy within how many days? Of course 30 days. And here board will be providing the recommendation, and you will simply see that board has recommended this particular vacancies for, board has recommended Mr. A, right, that for Mr. A's replacement we are going to bring Mr. B. And here what will happen now? Because the vacancy arose due to the resignation of Mr. A, members must approve B, and the general meeting must be held within how many days? Within 3 months of the board's recommendation, and then he will be continuing who? Mr. B, his office till the conclusion of the next AGM. Fine. Next, let's talk about a company whose accounts are subject to audit by an auditor appointed by the Comptroller and Auditor General of India, filed by Comptroller and Auditor General of India within 30 days. So what is happening here? Here you will see that for a company whose accounts are subject to audit by an auditor appointed by CAIIB, that is happening for whom? Of course, our government company. So we are saying that okay, the first authority will be given to the CAIIB, who will get 30 days to fill this particular vacancy. Now let us say that CAIIB could not fill this vacancy within those 30 days. So we are going to provide this responsibility to our board, and board will also get next to 30 days. Fine. Consider that here the board has filled this particular vacancy, right? So here you will understand that simply the auditor must be appointed by CAIIB and be filed by the CAIIB, Comptroller and Auditor General of India within 30 days. Provided in case the CAIIB of India does not fill this vacancy within the 30 days period, then the board of directors shall fill this vacancy within next to 30 days. Okay, you understood this part. With this, our section 139 is officially covered. Now I have to make you understand few things. Okay, tell me one question. ABC Limited is a non-government company that was incorporated on, let us say, 1st of April. Okay, this is a question to you. And now I am simply saying that the board of directors had failed to appoint the first auditor within 30 days. Who is going to appoint the auditor? So here, members at extraordinary general meeting. So if the board will fail, then members at this extraordinary general meeting will fill the vacancy within 90 days. Okay, and if the first auditor of a company, government company, needs to be appointed, then who is going to appoint them? CAIIB, Comptroller and Auditor General of India, within how many days? 60 days. Fine. Okay, one more important point. See here, there are few changes that have taken place. So section 139 is not just saying that okay, we have to appoint an auditor at the first AGM. Fine. It is also saying that before the appointment, the company has to take auditor's written consent. Okay, company has to take what? Auditor's written consent and a prescribed certificate regarding eligibility and condition of appointment. So here you will see about the more part of this particular thing in your section 141. Also, here you have to remember that an auditor appointed under this particular section ordinarily continues from the conclusion of the AGM until the conclusion of 6th AGM. Fine. Which is why you should not basically understand that okay, the provision is just appointed every AGM. Here it is AGM from 1st AGM till your 6th AGM. Okay. Now next to conclusion of 6th AGM, and next one is that one compliance point that was related to your Ministry of Corporate Affairs, that said that ADT 1 has been updated to cover the first auditor as well as for the current practical compliance. So here we are not saying that if there is first auditor, then we are not going to file this ADT 1. We have to file this ADT 1 then also. Understood? Now next part, let's talk about section 140, where we are going to talk about removal, resignation of auditor and giving of special notice. So section 131(9) was basically who was appointing the auditor. Now we are asking that once appointed, how can the auditor leave and how can the company remove it? Fine. So here we are going to understand this particular section into 3 parts. What if company wants to remove this particular auditor? Then we are saying that okay, what if auditor resigns by himself? Or we are going to talk also about NCLT, right? National Company Law Tribunal, or central government who will get involved because of the misconduct. So let's study this one by one. So first of all, let's talk about removal and resignation. Fine. So here we are saying that auditor may be removed from his office before the expiry of his term only by a special resolution, after obtaining the prior approval of the central government in the prescribed manner. See, suppose ABC Limited says that okay, I have appointed XYZ and company as my auditor. Fine. And now here we have decided that we don't want them to continue. So can the board simply remove the auditor? Of course not. So there has to be a passing of a special resolution plus previous approval of the central government. Okay, so here you have to understand that this is the sequence. Company will pass a special resolution, take a prior approval from the central government, and then only will go for the removal. So why is this removal of auditor so difficult? Because the law wants the auditor to remain independent. Imagine the company had appointed this particular auditor. Now what happened? Here the auditor discovers that companies have some kind of serious irregularities. Now what will happen? Here company, it will flag the issue, right, or it will raise the issue. So management gets angry and says that okay, remove him tomorrow. And if the board of directors could simply remove him, the auditor's independence would be badly affected. That's why the law puts an extra protection around his removal. Understood? So appointment is easy, but premature removal, it is very difficult to. Now application to the central government for removal of auditor shall be made in which form? Form ADT 2. So here what we are saying that okay, XYZ is the auditor, right? Now company wants to remove him, and before his term expires. So here you will see that board of directors have passed a special resolution and initiated this particular removal, but now company will make an application to the central government through form ADT 2. So here the application must be made within how many days? Within 30 days. Okay, so here what we are saying? We are saying the application must be made within 30 days from the date of board resolution, and here then the central government suppose grants the approval. So does the auditor automatically gets removed? No. Here the company must hold a general meeting. After holding this general meeting, it has to pass a special resolution, and the meeting must be held within 60 days of what? Or from the receipt of government's approval. Okay, so here you will see application shall be made to the central government within 30 days of the resolution passed by the board. The company shall hold the general meeting within 60 days of the receipt of the approval of the central government. So here now we are talking about in case of government companies and non-government companies, what is happening? We are saying the auditor who has resigned from the company shall file within a period of 30 days from the date of resignation a statement using form ADT 3 with the company and the registrar indicating the reasons and other facts related to his resignation. So here we have to understand that auditor can be removed by special resolution. This statement is not complete. Here we are saying that before expiry of term, auditor can be removed by a special resolution and after previous approval of the central government. Also we are saying that now because auditor has resigned, he himself or maybe he himself wants to leave, right? So here they have to file. An auditor who is resigning, right, who is leaving the organization must file a statement giving reasons for resignation and other relevant facts in the form ADT 3, and the statement must be filed within 30 days from the date of resignation. And who will get this ADT 3? See, for a normal company, the auditor files it with the company, registrar, fine, and here you will see that auditor has to resign and file this form within 30 days only. But with government company, there is one extra destination that we have been talking about, that is Comptroller and Auditor General of India, and we are saying that within 30 days of resignation, the auditor must additionally file this statement with the CAIIB. Okay, so for a normal company, it is company plus ROC, but for a government company, it is company plus ROC plus CAIIB, and the time period for both the companies will be 30 days that we are providing to whom? Our dear auditor who has resigned. So here we understood one simple thing. Okay, let us say that XYZ and co-auditor basically has been the auditor of ABC Limited. Now he has resigned on, let us say, 1st of August 2026. Okay, now what will happen? By 31st August 2026, he has to file which form? Form ADT 3. Fine. Now we are saying that for a normal company, it has to be filed with company plus ROC. For a government company, company plus ROC plus CAG. Now I hope you have just rectified it or learned by heart at least, okay. So in case of government companies, the auditor shall additionally file a statement within a period of 30 days from the date of resignation with CAG. What will be the penalties now? See, here we are saying that for default in filing the resignation statement, initial penalty will be 50,000 rupees. If the default continues, there will be an additional penalty of 500 rupees per day or equal to the remuneration, whichever is less, and maximum penalty can go up to 2 lakh rupees. Okay, so here we are simply saying 50,000 rupees of penalty for continuing contravention, for 500 rupees per day, and that can go maximum 2 lakh rupees. Fine. Now will come the most interesting part, that is National Company Law Tribunal. So Section 140 is also dealing with the situation when an auditor is found to have committed serious misconduct. So here what we are saying that okay, suppose an auditor is found guilty and the tribunal or NCLT has passed a final order against the auditor. What will happen? The auditor gets a major consequence, that is 5 years of disqualification. Okay, and here we are saying that the auditor, whether an individual or a firm against whom this final order has been passed by the tribunal or NCLT, is not eligible to be an auditor or to be appointed as an auditor of any company for how many years? 5 years. From which date? From the date the tribunal has passed the order. Okay, this is also very important. I hope you have understood and it is clear to you. So now what we are saying, that let us say that NCLT has passed the order on 10th of August 2026. So auditor will become ineligible for appointment as an auditor of any company for 5 years from 10th August 2026. So fine. So NCLT order will be filed from NCLT order to 5 years. Fine. Why is this rule existing? Can someone tell me? See, if an auditor has been found sufficiently at fault by the tribunal, the auditor should not immediately go and audit another company. There is some serious tribunal action going on, and here auditor has lost his eligibility and also the credibility, and that's why we are taking a 5 years bar on him. Fine. Also, central government application to tribunal can be filed. So if the application is made by the central government and the tribunal is satisfied that any change of the auditor is required, it shall within 15 days of the receipt of such application make an order that he shall not function as an auditor, and central government may appoint another auditor in his place. So central government itself can make an application to the tribunal. Suppose central government believes that auditor needs to be changed. If the tribunal is satisfied that the change of auditor is necessary, it can order that auditor shall not function as an auditor, and central government may appoint another auditor in his place. And tribunal has to make this order within how many days? Within 50 days of what? Receiving the application from central government. Okay. So you understood these two parts. Situation 1 says that final tribunal order against auditor, so 5 years of ineligibility of that auditor. Situation 2 says that okay, central government had applied to the tribunal and tribunal says that auditor should stop, and here we are basically providing or this order or passing this order within 15 days from the receipt of application from the central government. So this was a very simple and very easy section. Now let's move towards our next section that talks about eligibility, qualification, and also disqualification of our auditors. So here we are saying that before a person will become an auditor, is he qualified? Is he independent? Does he have any disqualification? All this must be known to us. So here under section 141 clause 1, a person can be appointed as the auditor of a company only if he is a CA in practice, not just CA but CA in practice. Okay, so we are saying that suppose there is a person Mr. A, who is a chartered accountant but is working as a full-time employee in a company, can he be appointed as a statutory auditor? No, because section 141 requires the auditor to be the CA in practice, and full-time employee itself creates a disqualification, and that you will see under the section 141 clause 3. So, where a firm is appointed as an auditor of a company, only the partners who are CA in practice shall be authorized to form by the firm to act or sign on behalf of the firm. So, here we are seeing that what if a firm is appointed? Suppose ABC and Associates okay. Now, what they are doing? Here they are being appointed as auditor, and the firm has 3 people who are, let us say, A, B and C, where A and B are CA in practice, while this particular person C, he is a non-CA partner. So, can he sign the audit report merely because he is a partner of the firm? No, only partners who are CA in practice can be authorized to act and sign on behalf of the firm. Okay. Now comes the biggest part, that is qualification, or better say disqualifications. So here you will see the most exam questions are coming from this particular clause. Instead of memorizing these clauses, you have to understand what are those 9 no rules. Okay. So here, none of the following persons shall be eligible for appointment as an auditor of a company. So basically, this qualification has 9 rules. So here we are saying that who must not be the auditor. First of all, a body corporate cannot be appointed as an auditor. So suppose XYZ Private Limited, a company, offers to become statutory auditor of ABC Limited. Can XYZ Private Limited be appointed? No. A company itself cannot be appointed as the statutory auditor. Okay. Understood? So here we are saying that the law is generally permitting whom? An individual CA or a CA firm, right? But we are never saying a body corporate. Next to who can be to? Officer or employee of the company. So here we are saying that an officer or employee of the company cannot be its own auditor. Suppose ABC Limited has Mr. Raz, who is also a chief accountant of this particular company or chief accountant officer. Now, can he simultaneously become statutory auditor? No, of course not, because the auditor must be independent. So, employee cannot be an auditor. Okay. Third, a person who is a partner or who is in the employment of an officer or employee of the company. Now, what we are saying here? We are saying that section 141 clause 3C says that a person cannot be an auditor if he is a partner of the officer or employee of the company or in employment of such officer or employee. For example, ABC Limited CFO is ABC Limited has a chief financial officer or who is Mr. X. Now, Mr. X is also a spouse of whom? Mr. X is spouse, a partner in CA firm. Okay. Now, can that firm be appointed auditor of ABC Limited? No. Here what is happening? Spouse, Mr. X spouse is, let us say, Mrs. Y is a partner in a CA firm. Now, you are not going to appoint the CA firm as the statutory auditor for ABC Limited. Fine. So, this clause is concerned with a person who is a partner of or in employment of an officer or employee. So, the relationship is not simply any relative. The exact statutory relationship matters here. Okay. So, here we are not saying that anybody related to an employee. We are simply saying partner. Okay. Now, a person who or his relative or partner. Now, here you have to understand what we are saying. We are saying a person becomes disqualified in specified circumstances if the auditor relative or partner has certain financial relationship with the company or a group. So what are we saying here? We are saying that there are three financial danger zones. What are those? Security. We are talking about what? Debt. Also we are talking about guarantee or security for someone else debt. Okay, so here we have to remember these SDG things. See here, you will see a person who or his relative or partner is holding any security of the company or its subsidiary or of its holding or associate company or a subsidiary of such holding company of in value in terms of such percentage as may be prescribed. Meaning we are saying, suppose the auditor, his relative, a partner holds shares or securities in the company. Okay, also we are saying the subsidiary. Okay, or we are saying what? We are saying holding company, associate company, subsidiary of the holding company beyond the prescribed limit, then the person is disqualified. For an example, let us take an example that there is a CA. Let us take the name CA Rohan. Okay, now there is CA Rohan who is proposed to be an auditor of ABC Limited. Just proposed. Okay, I have not made him the auditor as of now. Now what I am saying, that Rohan's relatives hold shares in ABC Limited. His relatives have some shares in this particular, let us say his father has some shares in ABC Limited. Does any holding automatically disqualify Rohan? No. The law refers to the prescribed limit, and this is extremely important for you to understand. So any shareholding will not lead to the disqualification. So holding security beyond the prescribed limit will lead to the disqualification. Okay, first part understood. Next, is indebted to the company or its subsidiary, or just I will read the theory later, otherwise you will not be able to understand. Suppose the auditor or the specified relative or partner is indebted to the company, its subsidiary, its holding company, associate company or subsidiary of holding company beyond the prescribed limit, then he will be disqualified. So suppose this Rohan, he has borrowed money from ABC Limited. Okay, now it says that, okay, what I will do, I will become an auditor of your organization. So if his indebtedness crosses the prescribed statutory threshold, he will be disqualified. So if the auditor owes company a lot of amount, then there will be no audit that can be conducted by him. Okay, then here we are talking about guarantee or provided any security with connection with the indebtedness of third person. So here suppose Rohan himself has not borrowed from ABC. Instead, his friend has borrowed from ABC Limited. Who? His friend. Okay. Now Rohan gives a guarantee for that borrowing and says that if the guarantee or security here is not paid by my friend, I am going to make you the payment. And now in this situation, what will happen? If this guarantee is also basically exceeding the prescribed amount, Rohan will be disqualified. So remember, auditor can be disqualified because of his own debt or his guarantee or security for another person's debt. Understood this rule? Now, a person or a firm who has business relationship with the company, its subsidiary, holding, associate company, subsidiary of such holding company or associate company of such nature as may be prescribed. So here we are saying, just let me teach you through an example this particular part. There is a CA firm, let's give it some XYZ name, PQR Limited. Okay, now PQR and Co. Now it is proposed to audit which company? ABC Limited. Now suppose this PQR, okay, it is also has a business arrangement with ABC Limited. Now you will be seen that if the relationship is of the prescribed nature, then it will be disqualified. So auditor should not commercially be tied to this particular company. Fine. Now comes the concept of key managerial personnel. So here we are saying that a person is disqualified if his relative is employed by the company as director or KMP. Suppose there is a CA Neha who is proposed as an auditor of ABC Limited, and her mother is a MD of this ABC Limited. Now, can she be appointed? No, because the relative is employed as a director of key managerial personnel. Understood? So here the law doesn't say that relative working anywhere in the company is disqualified. We are simply saying it refers to a relative being employed as the director or KMP. Understood? Next, now this is something very important. So here we are saying that disqualification is related to more than 20 companies. A person cannot be appointed as an auditor if he is already holding appointment as an auditor of 20 companies already. Okay, so basically subject to statutory exclusion. So here you have to remember that the clause excludes certain companies from this 20 number, where we are saying that one person company, you remember OPC, dormant company, small company and private companies that have paid up share capital less than 100 crore rupees. Okay, so in this 20 number we are not counting all these companies. Fine. So here we are saying that suppose there is a CA who is an auditor of 18 ordinary eligible companies and 4 one-person companies. Does he necessarily cross the statutory ceiling? Nahi. Why? Because 18 companies will be only counted. All those 4 companies are one-person companies, and these have been provided an exclusion. Okay, understood? Now suppose CA is there and he is an auditor of 20 counted companies plus 3 small companies. So small companies are excluded from the calculation and the count still is 20. So he cannot cross the limit merely because of the excluded companies. Okay, so auditor is already auditor of, let us say, 21 companies, therefore he is automatically disqualified. Okay, understood? So here 20 companies after exclusions. So a person who is a full-time employment elsewhere, or a person or a partner of a firm holding appointment as its auditor, if such person or partner is at the date of such appointment or reappointment holding appointment as an auditor of more than 20 companies, fine, he will also be disqualified. Next comes full-time employment elsewhere. Here we are saying that a person who is in full-time employment elsewhere cannot be appointed auditor. So if, let us say, CA is there who is working full-time as an employee of company X, can she simultaneously accept the appointment as an statutory auditor of company Y? No, because the full-time employment restriction will be applicable. Now we are talking about fraud. Okay, so what we are saying? We are saying that, okay, if a person has been convicted by a court for an offence that involves fraud and is disqualified if 10 years have not been lapsed, okay, from the date of conviction. So suppose there is a CA who was convicted of some fraud on 1st of January 2022. Now, can he be appointed as an auditor in August 2026? Of course not. Why? Because only 4.5 years have been passed, so the statutory 10-year period has not elapsed. So when does the bar will end? 10 years from the date of conviction. Fine. Next, a person who is directly or indirectly rendering any service referred to in section 144 to the company or its holding company or its subsidiary company. So we are saying that a person is disqualified if he directly or indirectly renders any service referred to in section 144 to the company, holding company or subsidiary company. So this is not about non-audit services. Basically we are saying that auditors shall not become too financially involved in consulting or services for the same audit client. So here we are saying that suppose CA firm XYZ is the statutory auditor of ABC Limited, and here what happens that XYZ auditor of ABC Limited simultaneously goes and says that I will be providing prohibited services covered by section 144 to this ABC Limited, it will create an independence problem. Fine. So here section 141 was asking can I be the auditor, section 144 is asking what services can auditor not provide. I hope this is clear to you. Now let's talk about casual vacancy, that is 144 clause 4. So here you have to understand that suppose there is our CA Rohan, he was validly appointed as the auditor of ABC Limited. Now at the time of his appointment he satisfied all the eligibility requirements. 6 months later something changed. For example, he acquired a disqualifying interest. Okay, he acquired a disqualifying interest. Now you will see that he will not remain the auditor until his term ends. So here section 141(4) says that if auditor incurs any disqualification after appointment, he shall vacate his office and the vacancy will be treated as the casual vacancy. So ABC Limited appointed CA Rohan as an auditor. At the time of appointment he was eligible, later he incurred one of the disqualifications under section 141(3). So now imagine he enters into a prohibited business relationship, then he will become disqualified, he must vacate his office and the vacancy will become a casual vacancy. So you understood the relationship between section 139, that who is appointing the auditor and then who is eligible to be the auditor. Fine. I hope this is clear to you. Now you can see, where a person appointed as auditor of a company incurs any of the disqualification mentioned in the subsection 3 after his appointment, he shall vacate his office as such auditor and shall vacation be deemed to be a casual vacancy in the office of the auditor. I hope this is clear to you. We have completed our section 141 as well, and next section will be our section 142, where we are going to talk about the remuneration. In the section 143 we are going to talk about his roles and the reports. Okay, so these parts we will be covering in the next lecture. For today let's keep it up to here, and I hope this is very much clear to you. This part will be completed in the next lecture. Fine. So of course this is a big chapter, but we are going to cover it nicely. So there is a lot to learn as of now, and if you are having any kind of doubt you can definitely ask me. Otherwise let's end with the session. First of all, press the like button, then you can comment if you have any doubt. Also if you have any feedback, recommendations or something you have, you can directly just message me or connect with me. And please start your preparation now, because there is too much speculation going on that which exam will come, and PFRDA will come or not, IFSCA will come or not, SEBI will come or not. Something will come and you must have knowledge for that. You must be prepared. Or if you are trying to think that okay, I just need to give one exam and clear this exam, then it's up to you, that focus on that one exam first of all. For example, few people have shifted towards APFC. Okay, prepare for that, prepare well. Okay, that's it for the day. Thank you so much guys. Bye bye, take care.